Hi, everyone. Welcome to another episode of the Ask Amity Show. This is part 3 with the LA County Assessor, Jeff Prang. Welcome back, Jeff.
Thank you. Good to be with you.
So today we have another series of questions for you to answer. And the first one is, my wife and I own a real property titled husband and wife as community property. She recently passed away. Will the property be reassessed?
So typically, in this case, not. Presumably, when the husband passed away, his interest transferred to his wife. And because transfers between spouses do not constitute a reassessable change in ownership, the property should not be reassessed. However, the wife's passing should be reported to the assessor's office by filing what's called a change in ownership death of real property owner form. This is actually something required by law. When there's the death of a property owner, the heirs or the estate is required to notify us within 150 days of the death of the property owner. We're required to maintain accurate and updated records about who owns property. And whenever there's a death of a property owner, the change in ownership occurs at the time of death.
Okay. And here's a really common question that we get all the time. How can you prove primary residence?
One of the primary ways that we determine whether property is your primary residence or not is through the homeowner's exemption or the disabled veterans exemption. And under Proposition 19, where you're required to occupy the home of your parents or grandparents that you inherit in order to continue the tax benefit. However, the property has not been receiving either the exemption, but now seeks to prove that the property is the primary residence. There's other forms of evidence that can be submitted, such as the driver's license, tax returns, utility bills, proof that they're not having the homeowner's exemption or disabled veterans exemption applied to a different property.
Okay. Next question deals with joint tenancy. I know joint tenancy is a little bit tricky when you make changes to it. So this question applies to a parent wanting to add a child on as a joint tenant, but they later change their mind and want to transfer it back from the child back to the parent. So removing or breaking the joint tenancy. Does that cause the property to get reassessed?
So generally speaking, no, it should not result in a reassessment, although the specifics of the details are very, very important. A very simple transfer and transfer back. After a joint tenancy such as this is formed, if there is a transfer that results in the original owner's reacquisition of that property, no reassessment should occur. But that if there's other details that are left out of this example, that could result in a different outcome.
So this one would apply to the parent to child exclusion then, because the
yes,
child.
So you can transfer your child, and the child could transfer it back without reassessment.
Okay.
Okay. And so our last question is, if a transfer on death deed was recorded before the new law, do I need to send notice to the beneficiaries when it comes time to transferring the property?
So those beneficiaries that will inherit the property upon the death should be made aware prior to the death that they will need to apply in a timely fashion for a Prop 19 exclusion after the death of the property owner if they wish to retain the tax base or otherwise receive a Proposition 19 exclusion. Most notably, the beneficiaries need to move into the property, file the homeowner's exemption or the disabled veterans exemption within 1 year of inheriting that property.
Okay. Well, those are really, really helpful. We get a lot of these questions from our clients and people who are calling our office for assistance in transferring property. And with Prop 19, there's just been so many things to worry about and to look out for. So thank you for coming on and answering a lot of these questions for us. Hopefully we can do this again.
Absolutely. Glad to shed a little light on the subject.
Thank you.
Thank you, Jeff.
Thank you. Good to be with you.